Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Hi there, welcome. If you're not sure what your workplace rights are, this is the show for you. Welcome to Ask a Lawyer. I'm your host, John Scholes. Every week, we shatter myths and clear out the confusion about your employment rights in Canada and how to get the advice and compensation you need. Joining us, employment lawyer Lior Samfiru, partner at EmploymentLawyer.ca. Now, before we get into today's questions and phone calls, Lior, tell us why it's important, so important, that everyone knows about their employment rights, and maybe a case from the past week that we can all learn from. What do you say?
Well, I started doing radio and TV some 10 years ago. It's because I went on this message board reading about some hobby, and all of a sudden someone started asking questions about their employment law rights. They lost their job and they were asking questions about how much they owed. And about 50 people pitched in with answers, and they were all wrong, each and every one of them. And that's when I realized, my gosh, there's so many misconceptions out there about employment law. But employment law is something that we all need to know about. We all have a job, we all work, so we need to, all of us, understand employment law rights. And that was the idea for starting to educate the public, to provide this forum for us to tell people what they need to know if they lost their job, if they're worried about losing their job, if they're put on a temporary layoff, which, by the way, is not legal, if you've been a victim of harassment or a bullying or a poison work environment. What do you do? Who do you talk to? That is why it's so important that we're here and we have this ability to communicate with you and tell you what to do and what to understand and what to say if you're in a workplace situation. And of course, if you ever want to have a private chat, you want me to roll up my sleeves and get to work to help you to resolve that workplace problem, we'll give you my contact information throughout the show so we can have a private chat or private email exchange. But let's start off with the situation that came across my desk, which I think gives you a good sense of these misconceptions and confusion that may rest with respect to employment law. So I spoke with a gentleman who had worked for a company for 10 years. 3 years ago, that company was sold, and he continued working with a buyer. He continued working on same job, same pay for 3 years. Now, unfortunately, the company has done a major restructuring, and as a result of that, he has lost his job. Now, they offered him 3 months severance. That didn't seem right to him. So he asked them, well, why is it only 3 months? Why am I not getting more? Well, they said, well, you're a 3-year employee, so we're giving you 3 months severance. We think that's fine. He called me. He wanted to understand, are they right? Am I owed more? So let's start with the fact that even if he truly, really was a 3-year employee only, he was owed more than 3 months severance, probably about 6 months severance. That's assuming he's a 3-year employee. Is he? No. And the reason for that is with the sale of a business, if your business is sold and you continue working with the buyer, they inherit your service, which means he's not a 3-year employee, he's a 13-year employee. 10 years with the previous company and 3 years with the new employer. So he's a 13-year employee. He's owed severance as a 13-year employee, which for him is about 14 to 15 months of severance. That's a huge difference. And I wanted to remind everyone out there, employees and employers too, that if there's a sale of a business, generally speaking, the seniority carries through. And that's important because if you're let go down the road, the severance is going to have to account with the time you had with the previous company. Now, one thing you want to really watch out for is this. If you sign an employment agreement with the new company, the company that's bought the business, it's possible that that employment agreement may say that you're giving up that past service. So you want to watch out for that and don't agree to that. You can negotiate that out or get me involved and I can help you. Don't want to give up on that past service because that could impact your severance significantly later on.
You can contact employment lawyer Lior Samfiru and his team directly by going to employmentlawyer.ca or calling 1-888-861-4555. Time for the first call of the show. Lior gets these calls. They come to us from our radio shows across Ontario, including Employment Law Show, heard Sundays, 1 p.m., News Talk 1010, where we take live questions from listeners about their employment law concerns. Let's listen to our first one.
This company that I work for, it's laying quite a bit of us off, right? I've been with the company for 25 years. My salary is around the 96K a year. I got a 20-week working notice and no benefits whatsoever after that. I'm 50. I am a computer programmer.
So let's break this down. So you got 20 weeks notice of termination. Now that 20 weeks notice does count towards his severance. So if your employer gives you written notice of the termination of your employment, that amount of notice that you receive does count towards your severance. It does count. But that does not mean you're not owed much more at the end of that notice. So in this situation, the question becomes, after 25 years, is he owed more than the 20 weeks notice? The answer is absolutely, and in fact, a lot more. So let me show you how you at home can find out exactly how much this person, how much you're owed, how much your friends are owed in terms of severance. You grab your smartphone, you grab your tablet, you go to pocketemploymentlawyer.ca, you use our severance calculator tool. I'm going to do that right now. I'm going to plug this information from the call that we just received, and let's see how much severance he's really owed. So we know he's been there for 25 years, 50 years of age, makes $96,000, and received 20 weeks notice. Well, you can see on the bottom of the screen that the real amount is 18 to 24 months. That's a lot more than 20 weeks. 20 weeks is called, 5 months or so. Yeah. He's owed as much as 24 months. So that's a wrongful dismissal. He did not receive enough notice, and the company has to make up the difference by way of severance. So at home as well, chances are, if you've received notice of termination, you're owed much, much more. And the easiest, the best place to get started to find out how much more is just go to pocketemploymentlawyer.ca, use the severance calculator, which of course is free and anonymous, and get the answers.
All right, we'll take a quick break, and when we come back, employment lawyer Lior Samfiru from EmploymentLawyer.ca will explore some of the most ridiculous allegations of termination for cause he has seen. Ask a Lawyer returns in a moment.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
All right, welcome back to Ask a Lawyer. Employment lawyer Lior Samfiru from EmploymentLawyer.ca is tackling questions about your workplace rights. Get in touch with Lior and his team. Email ask@employmentlawyer.ca or call 1-888-861-4555. There you go. Or go to EmploymentLawyer.ca. All right. We'll get to more phone calls and questions in a moment, but first, today's main topic, ridiculous allegations of termination for cause, and some key takeaways, our viewers. First one, your employer changes performance targets, then fires you for bad performance.
So all these situations, John, are situations that I've came across over the years. And remember, before we even start, it is difficult, very difficult to terminate someone for cause. It's not enough that the person did something wrong or even a few things wrong. It would have to be so bad that they can't be employed anymore. And then and only then can a company potentially let you go for cause. Now, in terms of what you were saying, the company changes the targets and then punishes you for not meeting them. That's ridiculous. That's silly. If that was cause, think about it. I could just give anyone unreachable targets and then punish them and not have to pay them severance because they don't meet them. No. Targets have to be reasonable and attainable. And a company, by the way, doesn't have the ability to just change those targets unilaterally. That could also be a constructive dismissal. And you certainly can't be let go for cause in that situation. That's ridiculous. If that happens to you, yeah, you're probably sitting on a wrongful dismissal.
Okay, next one is we discuss ridiculous allegations of termination for cause. You did not provide a medical update from your doctor the very same day you were asked to provide one.
So employee, you're sick. We know you're sick. You're really sick, but we need an update today
now
from your doctor. Well, clearly you can get into a time machine and force your doctor to deal with you today. That's ridiculous. That's silly. It is reasonable for your employer to ask for an update from your doctor, but they have to give you sufficient time to get it. So they can't demand today or tomorrow. They got to give you some time. And maybe that's a week, maybe it's 2, maybe it's a few weeks. And an employer cannot punish you for not giving them a doctor's note on demand on the same day that they ask for it. That's ridiculous. That could potentially also be a human rights violation. They could be setting you up in that situation to let you go. I've seen it happen, John, and it's illegal.
We are running through ridiculous for-cause terminations on Ask a Lawyer with employment lawyer Lior Samfiru. Third on our list here, you were late for work because of a traffic accident or bad weather.
Well, bottom line is you can only be terminated for cause for something that you did purposely, for something that you should have avoided. Now, I'm not suggesting to you that if there's bad weather, you don't have to plan accordingly. Maybe that means you leave home earlier to be at work on time. But unless it's something that happens all the time, unless you've been warned and you don't care and you do it again and again and again, then and maybe only then can the company consider letting you go for cause. But because, you maybe left a bit too late or you didn't expect the accident on the 401, that does not mean that you can be let go for cause. Ridiculous, and again, wrongful dismissal.
Okay, ridiculous reasons to fire someone for cause. Number 4, you push back on a pay cut or demotion.
So an employer does not have the ability to make unilateral changes, significant changes to the terms of employment. And if they do, that could be a constructive dismissal. And you don't have to accept it. And you don't have to just do whatever it is that your employer wants you to do in that situation. You can tell your employer, no, I'm not accepting this demotion. I'm not accepting the pay cut. And if that the company tries to use as grounds to terminate you for cause, that's ridiculous. That's never going to fly. You're going to be owed your full severance. And that severance, John, can be as much as 24 months pay. Ridiculous. I've seen it happen. Doesn't work. If it happens to you, you call me.
Okay, our last ridiculous reason to terminate someone for cause, you cause trouble by complaining about legitimate workplace harassment.
Well, this is actually worse because you have to and you should complain about workplace harassment. You have to tell your employer if you're being harassed, if you're being mistreated, if you're being bullied in the workplace. And your employer not only cannot fire you, they have to take it seriously. They have to investigate. They have to ultimately rectify that problem. It's illegal to let you go for cause or without cause because you complain about harassment. We call that a reprisal. It's a breach of several statutes, potentially human rights violation as well. You should always feel comfortable to tell your employer about harassment, to demand that they deal with it so that you work in a proper work environment. And if that doesn't work, if they don't do that, or they try to do anything to you, you give me a call.
Okay, EmploymentLawyer.ca is the easiest way to contact Lior Samfiru and his employment law team for help. Then jump on another phone call. We're going to get to that right now from one of your radio shows, Lior. Let's do it.
I've been with my employer for 23 years. I'm still employed there. I had to sign a revised employment agreement a number of years back. Everyone did in our organization. I didn't seek consultation from an employment lawyer at the time. I don't have any concerns about my job or whether I'll be let go. But should that happen, will that dictate then what I'm entitled to, or would I still have the ability to negotiate?
So always a good idea. If your employer wants you to sign an employment agreement, you got to give me a call. Let me see what it says. Let me tell you what it means so that you don't end up signing something that you shouldn't sign. It's bad news, always is, when your employer out of the blue wants you to sign a new employment agreement. There's probably terms there that do limit your future severance, or terms there that give the company the right to do things that they otherwise would not have the right to do. So very, very important not to just sign an agreement without realizing what you could be giving up. And again, good idea to have me review it. Now, it's possible that that agreement that you signed may be binding on you and now you're stuck. But that's not for sure at all. Maybe you didn't get anything in return for signing it. Maybe the agreement itself is not worded properly. We can get around agreements for many, many reasons. So never assume just because you sign something, you end up being stuck with it. We may be able to get you out of it. But the best advice I'm going to be able to give you about employment agreements is this. Before you sign it, before you put your signature on that dotted line, let me see it, let me understand what it says, and let me help you negotiate it if needed.
You can connect with Lior Samfiru and his team by emailing ask@employmentlawyer.ca or going to employmentlawyer.ca. After the break, we'll talk about wrongful dismissal for a pharmacist and the truth about temporary layoffs in Canada. More to come on Ask a Lawyer.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back to Ask a Lawyer. Employment lawyer Lior Samfiru from EmploymentLawyer.ca is taking your questions about your workplace rights. To get in touch with Lior and his team, email ask@EmploymentLawyer.ca or call 1-888-861-4555 or visit EmploymentLawyer.ca as well. We still have lots more to get through, including this call that came into your radio show, our radio show, which airs Sundays at 1 p.m. News Talk 1010. Let's listen to it, Lior.
After 7 years, I was let go without cause after ongoing harassment. Harassment was of 3 people, myself, my subordinate, and my counterpart, and I was terminated because I was a witness. They've paid, I believe, 1.5 weeks for every year work. My age is, I'm 36. I was a pharmacist.
What do you think?
Didn't I just talk about harassment and how it's not legal to be terminated because you're involved or you're a victim of harassment, you experienced harassment, or you've complained about harassment? You know, you have that dome of protection around you, which means you cannot be let go because you've incurred or you suffered from harassment. Not only can you not be fired, the obligation is on the company to deal with it, to investigate, to fix the problem, to make your work situation better. This person was let go. So right off the bat, we have legal breaches by her being let go because of this harassment situation. So number one, problem, illegal. The other issue, of course, is the issue of severance. She says that after 7 years, she was given 1.5 weeks of severance for every year worked. By my math, that's about 11 weeks. Is that enough? Well, let me tell you, but let me also show you. I'm going to go back to our severance calculator. You can find that at pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. Let's plug that information in there and let's see what that gives us. So a pharmacist, been there for 7 years, was offered 11 weeks, 1.5 weeks per year of service. But what we see at the bottom, she's owed really 6 to 8 months of severance. That's a huge difference between 11 weeks, which is less than 3 months, to 6 to 8 months of severance. So that's a wrongful dismissal above and beyond all the harassment stuff that we've already talked about. So yeah, this employer did something illegal. That's the bad news. The good news is there's always something you can do about that, and it starts by giving me a call so I can roll up my sleeves, get to work, and make it right. If that happened to you, you know what to do.
Yep, to get in touch with Lior and his team, email ask@employmentlawyer.ca, call 1-888-861-4555, or visit employmentlawyer.ca. Let's take a look at another situation that your firm has come across recently, Lior. My employer put me on a temporary layoff because business is slow. I don't think there's any chance of being called back to work. Also, I think my boss is just hoping to avoid paying me severance. What should I do?
Well, remember, we've talked about this before on the show, and I want to remind our viewers that a temporary layoff in most cases is not legal. Your employer does not have a right to put you on a temporary layoff, and you can treat that as a termination of your employment and make them pay you severance. So it's not a question of can they keep me on and for how long and is it legitimate. The problem is it's not legal to begin with. So when you're on a temporary layoff, believe it or not, you're the one that has the ability to make the decision how long. You can decide when you've had enough. You can decide when you're not sitting at home waiting and when you want your severance. So if you don't want to wait for that employer, you don't think they're calling you back, or maybe you don't want to go back, you can treat that as a termination and get that severance, of course, up to 2 years pay, up to 24 months of severance. That's the maximum that you can get, depending on how long you've worked there, etc. If that's your situation, before you tell your employer anything, I want you to give me a call. I want us to talk about it. I want to understand what you're owed. I want to understand how long you've been there. I want to understand the length of the layoff. And then we can go ahead and make sure that we get you that compensation, John.
All right, we'll take a break and return with Lior Samfiru, partner at EmploymentLawyer.ca. Can your employer refuse to pay severance and force you to take employment insurance instead? We'll find out next on Ask a Lawyer.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
All right, welcome back to Ask a Lawyer. Lior Samfiru from EmploymentLawyer.ca is answering your workplace questions. You can connect with his team, 1-888-861-4555. Email ask@employmentlawyer.ca or go to employmentlawyer.ca too. Time for another question. This one from one of your live streams on Facebook and YouTube, which people can find by going to stlawyers.ca. Says, I was just fired from an extremely specialized role after 1 year. When I asked my manager about severance pay, he said that compensation is taken care of through employment insurance. Should I apply for EI now, Lior?
So I actually get similar questions often. People calling me about things that they may not be what they really should be concerned about.
Right.
This person is calling me about EI. Oftentimes people call me about overtime, which is absolutely fine, but there's a bigger issue here, and that's the issue of the severance that this person is owed. Now, I'll give this employer maybe the benefit of the doubt. Maybe this employer is under the misapprehension that only large companies pay severance. Wrong, but maybe they believe that. Maybe this employer thinks that you have to work for a company for a certain number of years to get severance. Wrong. You don't. Even if you work for a few minutes, you still get severance. And not only does this person get severance, they said they're in a specialized position, John. That actually means even more severance. If you work in a specialized position, that means it's probably going to take you longer, right, to find another job than if you had worked for a company or in a job that's very easy to replace. So yes, she absolutely gets severance, this person, a significant amount. And again, depending on all the years of employment and the exact nature of the job, it could be as much as 24 months pay. That's the severance that she's owed. So I wanted to keep in mind, and don't believe your employer. It's nothing to do with EI. Severance has to be paid.
Well, you always think EI is a natural course. You know, Ministry of Labor, that's where I should be going, right? But no, there's more money there.
Absolutely. And yes, you may get EI. I could pay you for a year, but that's separate from severance. Your employer does not get to save on severance because you may qualify for EI. Those are separate things. Your employer's severance obligations result from them letting you go, from the time that's going to take you to find another job. You may be able to continue getting EI after that. If you still haven't found another job, that's fine. But severance has to be paid. And I want to be very clear. Long service, short service, senior position, junior position, part-time, full-time, does not matter. If you had a job and you lost that job, you're owed severance.
Employment lawyer Lior Samfiru, another great show. Thanks, pal. Thank you so much for your time. You can hear Lior live, News Talk 1010, every Sunday at 1 o'clock. We do our show, the Employment Law Show, where we take calls from radio listeners across the GTA. Catch legal experts from EmploymentLawyer.ca on Ask a Lawyer every Wednesday on CP24. For more information on this show and EmploymentLawyer.ca, visit cp24.com/askalawyer. And join us next week as we focus more on workplace harassment and how to handle it. Thanks so much for watching.